We are set.
Okay, good afternoon, everyone. This is a World Arbitration Update from Doha in 2024, and it is with great pleasure that I will be introducing the moderator. But before, let me share with you that my name is Jose Antonio Rivas. I am one of the co-founders of World Arbitration Update, which was founded 4 years ago. This is the 4th edition of World Arbitration Update, and the first time that we have an in-person panel from Doha. Much of it has been thanks to our moderator, Stavros Michalopoulos, and I would like also to share with you that I am partner at Eftekkhari here in Washington, D.C., and also professor of investment treaty arbitration, public international law, and ICJ judgments. And for today's panel, we have a great topic, which is international commercial arbitration, the limits of the public policy ground for setting aside or non-enforcement of arbitration awards by national courts. This is a very topical theme, considering that today there are various jurisdictions in the world that are seeing annulment or set aside request by parties that have had awards against them in various places, both in Europe, but also in MENA, as well as in the United States, among other places. With that, I would love to introduce Stavros, who has a vast experience in construction and engineering disputes, and has considerable experience advising contractors, employers, and developers and government institutions, with a particular focus on large-scale projects in the infrastructure, energy, oil and gas sectors. Stavros is a senior associate of DLA Piper in Doha. He's also an arbitrator. He's a member of the Young Arbitrators Forum and the Public International Law Group. He is also a qualified solicitor of the Senior Courts of England and Wales, and also qualified in Greece. Apart from that, it is with great pleasure that he was also my student at Georgetown Law, and it's fascinating that now he's doing full force international arbitration from Doha. So Stavros, take it away, and thank you for being here.
Thank you very much, Professor Rivas. I can only call you Professor Rivas, given the history in Georgetown a long time ago. It is a great pleasure to see you again after all these years. Hello again to everyone, and welcome to the 4th World Arbitration Update Conference, or as I like to call it, the World Arbitration Week. 2 weeks, actually, with events all over the world, with a view to informing the world about international arbitration, and more importantly, expanding it in the 4 corners of the globe. This is the first time that the conference is taking place in the Middle East and in Doha. And we at DLA Piper in Doha are very happy to be organizing it along with the World Arbitration Update organization. We hope that this is the beginning of a very fruitful collaboration. We're very excited to be doing it, and hopefully we can do it again next year. Let's go to the topic of this conference. Before I introduce the speakers, I'd like to make a couple of introductory remarks. As Professor Rivas said, the topic is the limits of the public policy ground for setting aside or non-enforcement of arbitration awards by national courts. As any arbitration practitioner is well aware, many of you are in this room, public policy, especially in this region, is one of the murkiest, most hotly debated concepts in international arbitrations, however, it has very real consequences, as it is one of the most commonly invoked reasons for set aside or refusal of enforcement. Successful or not, people use it parties use it very often. In general, I always like to say that a person's or a state's views on the limits of public policy basically reflect their views on arbitration. The proponents of a narrow scope of public policy or the European view of the international public policy generally tend to favor, at least in my view, the finality of arbitral awards and the predictability of the arbitral process, as well as the proliferation of the arbitration. On the contrary, we have the proponents of an expansive approach of public policy who focus on the wording of the New York Convention that allows courts to deny enforcement of awards that is against the public policy of that state. That gives, in their view, the understanding that only state courts can protect both substantive and procedural public policy and the integrity of the legal system of that state. And as a result, they favor granting them a higher degree of deference. The limits between the two trends that I have set out is going to be the main topic of our discussion. Thankfully, we have a stellar panel of speakers that will enlighten us today. Starting to my right, Professor Ilias Bantekas, Dr. Reza Eftekhari, who is joining us online, Mr. Constantine Christy, and Ms. Stella Lepturgou. In case you have not noticed, we have an absolute majority of Greek people here. That was entirely coincidental, I assure you. We start with Professor Bantekas. He's a professor of law at Hamad bin Khalifa University at the Qatar Foundation. And actually, Professor Rivas, he's also an adjunct professor at Georgetown University. He will provide a brief historical overview of public policy, the perceptions regarding the approach of the public policy of the Gulf state, and let's see whether he gives a more optimistic view with respect to the concept of public policy when it comes to recognition of arbitral awards. Professor Bantekas.
Thank you, Stavro. It's coincidental, you sure. So there's always this paradox with public policy, and the paradox is that while states make policies for investment, for commerce, for attracting business, at the same time, some time ago, they had left, what are the limitations to that, to the courts. The courts where judges, they might look at certain other private issues, and then they would take these huge decisions that something falls within the public policy domain, and therefore that then would hinder and inhibit the actual state policies. And that, I think that's a real paradox. That you can make a multi-billion-dollar policies, but then having judges to decide, nilly-willy, whether or not they favor something or not on the basis of public policy. And so there's always a dissonance between the actual policy makers and those deciding what is public policy. And we saw that in the 80s, 90s, and until the early 2000s, where courts made life or death decisions about issues affecting these state policies. And so when we did research back in, let's say, the early 2000s, we looked at public policy from the perspective of how many cases there are. And based on those cases, we looked at what the law on public policy was, regionally and globally. If we look at cases now, you struggle, you go, just a small Google search, we see that there are very few cases since the late 2010, so from 2000 onwards. And the reason, in my opinion, is because that dissonance is closed. So now there's a consonance between what states see as their policy perspectives and what they allow the courts to do. Now, I'm not sure how that has come about, but I think we have more sophisticated judges. Certainly, we have lawyers now being more savvy about what they feel might be a public policy risk or a disaster at some point. And so that's closed the gap. But certainly there are few cases, and maybe our colleagues here will say that's actually true, but that seems to be the trend. There's less public policy limitation cases coming from national courts. And we see that even in the GCC, which is notorious about the Sharia factor in some of these cases. Now, in terms of laws, we see in the GCC, we have the mandatory laws, of course, which can shape public policy. We have national visions, and for those of you who are not from the Gulf, national visions are the quintessential foundations of policy of the state, Now, they do set out the policy of the state in terms of what they want to do for the next 10, 20 years, but at the same time, they can be used as setting out public policy to a certain degree. Although that hasn't been, we haven't seen that in the literature, we haven't seen it, in what the courts do, but it can be used as that. And so what I want to ask is, everyone has seen, of course, New York Convention, Article 5. We're not always sure what this means in terms of Article 5. And I had a student many years ago in London who, did a PhD on the New York Convention, Article 5, and he came up in the vibe and said, Article V. He had realized that this was the Latin character, 5 years down the line, he thought it was Article V, as a letter. So when we look at this public policy in Article 5 of the New York Convention, into the public policy of the enforcing state, what we haven't asked ourselves is this public policy exception an exception to the general rule under international law that states cannot use their domestic law to override their international legal obligations? So is that what's the answer to that question? Can states use the public policy exception, Article 5, to escape their obligation under general international law, right? And that question has not been answered in that respect. My view is that it's a negative. No, they can't. There are certain reasons. One is that the public policy rules have to be transparent and certain. Why? Because that's a general principle of international law. You can't have non-transparent rules and think you can get away with it. That you override this is fine. Secondly, state laws have to be proportionate, whether it's a policy statement or whether it's a mandatory law. It has to be proportionate, and proportionality is actually the benchmark of a good application of the law by the courts. Thirdly, we know now, especially we knew it before, but after Germany versus Italy before the ICJ, we know that judgments of national courts are acts of the state, and as acts of the state, they can incur state responsibility for the state. It doesn't matter that we have separation of the powers. Courts are part of the state machinery, and so therefore they can get the state to incur state responsibility. So in that respect, the answer to the first question is whether or not public policy in Article 5 can be used as an exception to evade liability under international law. The answer is certainly no, because public policy, in effect, even if it's domestic, has to be curtailed by pertinent rules of public international law. And I will leave it there.
Okay. Very good, Professor Bantekas. Once again, very enlightening speech, and I really liked the public international law touch that you used in this particular case. I presume that you were talking about also the Articles of State responsibility, which basically forbid a state from invoking international law national law to evade its public international obligations. The question then, of course, is to what extent is the enforcement of an award a public international obligation, and this is something that we will discuss at a later stage. And this is, I think, the real separation between more internationally focused, academics, practitioners, and states, and more nationally focused. Because the counter argument to what you said is that when someone brings an international arbitral award to a state, for enforcement, that enforcement is a matter of the state. It does not involve, it stops having an international character. However, we do have the New York Convention, which is an international treaty that has been accepted and ratified. So it is a very, very interesting point of discussion. I would like to ask you one question. You mentioned that there is a consonance right now between what the state, I presume you mean the executive and the legislative branch, considers as public policy, and what the judges consider as public policy. And I was wondering, do you also see that in the Middle East, or is it something that you encounter in other parts of the world? Mostly.
Thank you, Stavros. You explained that really well. True. I think after the Bechtel case in the UAE, there's a huge turnaround in the way that the courts in DCC look at their role in interpreting public policy. I think that's really limited. And it's probably a self-limitation, I would say, more than anything else. But at the same time, I think the judges now throughout the Middle East. We have judges who have an international exposure, and so they feel that their place in looking at public policy has to be limited, except if the state kind of makes a meal out of a certain issue. And in Qatar, we see Article 1 of the Civil Code, which makes it clear that in terms of the hierarchy of sources, the code goes first, and then we have in second place we have Islamic law, which has a very limited role because for a number of reasons, and then we have business practice and even general principles of justice. And so it's quite clear that you can't escape from that.
I understand. So in your view, at least since the Bechtel case, as you said, it's more of a laissez-faire approach rather than a consonance. I understand the point. Okay. Thank you very much for that. We will continue the discussion later on. However, I would like to hear from our second speaker, Dr. Reza Eftekhari, who is joining us online. Am I correct to say that you are in the Netherlands, or is that incorrect?
Yes, that's correct.
Thank you. Dr. Eftekhari, he is a senior legal advisor at the Iran-US Claims Tribunal. For us public international law nerds, this is in my opinion, this has an equal value and the strength of law as the ICJ. That's my view. Many people disagree, but that's what I think. Dr. Eftekhari has dealt with public international law and contractual interstate disputes, and he's a practitioner in international investment and commercial arbitration, including ICC, arbitral, and other ad hoc arbitrations. He is the author of the book, The Role of Domestic Law of the Host State in Determining the Jurisdiction of the Ratione Materie of Investment Treaty Tribunals, the Partial Revival of the Localization Theory. I think that was published in 2021. Dr. Eftekhari will continue discussing the developments of public policy as a ground for setting aside or refusing enforcement. He's going to focus on the Middle East and the Gulf, and he will focus on the positive developments in favor of arbitration, but also describe the lingering perceptions on public policy that favor a more expansive interpretation in that region. In that sense, it would be interesting to see how your views differ or actually align with what Professor Bantekas has actually said. Dr. Eftekhari, you have the floor.
Thank you very much, Stavros. Good day, everyone. My name is Reza Eftekhari. It's a great honor to give this presentation on the occasion of the 4th edition of World Arbitration Update on the panel discussion of the public policy ground in post-award proceedings. Before finalizing my notes for this seminar, I leaf through the most leading publications on international commercial arbitration to see what has been said on the ground of public policy. What occurred to me immediately was that all these authoritative sources have a relentless focus on certain jurisdictions such as France, Switzerland, Singapore, the United Kingdom, and the United States, and have admired their pro-enforcement regimes, and also have made clear that these countries, the legal system of these countries, interpret the term public policy quite narrowly. This is, of course, unsurprising. Firstly, these countries, the judicial system and the legal system associated with these countries, are the vanguards of international commercial arbitration. And secondly, and maybe more importantly, these countries host the most popular seats in international arbitration. So it is critical to understand how public policy is understood and applied in these legal systems. But this substantial focus on these countries means that there is much more limited focus on what is going on elsewhere in the world. Luckily, this 4th edition of World Arbitration Update has provided us with the opportunity to have a more global view regarding international arbitration. And I'm availing myself of this opportunity to explore how public policy is understood and applied in the Middle East. And for this, I'm grateful to Dr. Jose Antonio Rivas and Professor Jan Led and their dedicated team at World Arbitration Update. In the next 12 minutes or so, I'm going to explain in general terms how public policy is viewed in post-award proceedings in various Middle Eastern jurisdictions. If you read articles written by jurists with a Middle Eastern background 35 years ago in various journals of international arbitration, you would sense doubt, reservation, and sometimes pessimism regarding international arbitration. Today, that perception has substantially changed. There are approximately 15 countries in the Middle East with a predominantly Islamic population. Out of these 15 countries, 14 have joined the New York Convention. Iraq was the latest country to become a contracting state in 2021. Again, out of these 15 countries, 9 have adopted the UNCITRAL model law on international commercial arbitration. Qatar was the latest to come on board in 2017 by adopting the UNCITRAL model law on international commercial arbitration. So the most significant instruments, the key instruments in international commercial arbitration have garnered significant appreciation in the Middle East. But more importantly, and more connected to our topic, courts in the Middle East, national courts in the Middle East, generally speaking, have tended to apply the New York Convention in a positive way. And more specifically, the ground of public policy has been really relatively interpreted narrowly in the last decade in various jurisdictions in the Middle East. And since this is World Arbitration Update, let me give you some fresh examples. Egypt. In 2020, a court in Cairo upheld an award rendered against a state entity in favor of a Kuwaiti-led consortium in the value of around $500 million and rejected the public policy arguments raised that this award against the Egyptian state entity has been rendered in violation of Egyptian public policy. Iran. In 2016, a court in Tehran not only made a distinction between domestic public policy and international public policy, but also interestingly made reference to various guides issued by multiple international organizations on the interpretation of the term public policy, and also urged the officials in the judiciary to translate the judgment and send it to ICA in order to promote harmonization in the application of the new convention. Saudi Arabia. In 2024, the Saudi Minister of Justice reported that out of 88 applications, annulment applications received in that year, only 5 of them were annulled partially or fully, and with none of them being based on public policy or Sharia law. And finally, the United Arab Emirates. Departing from past jurisprudence in 2023 or maybe 2022, the Abu Dhabi Court of Cassation dismissed the allegation that failure by the arbitral tribunal to sign all the pages of the arbitral award would violate procedural public policy. So these are quite fresh examples from the region, various countries in the region, and how they have approached the ground of public policy and dismissed various applications based on this ground mentioned in the New York Convention and also in arbitration acts. But to be frank, it is a fact of life, and it is no secret that the ground of public policy is a more effective weapon in the hands of the parties that resist enforcement or the validity of the arbitration award in post-award proceedings in various Middle Eastern jurisdictions. And in my opinion, of course, when I say this, I say this in comparison to the pro-enforcement regimes that I enumerated at the beginning of my presentation. In my opinion, there are 4 reasons for this more expansive interpretation of the ground of public policy. Firstly, there is a historical understanding in the minds of judges regarding the notion of public policy. Secondly, the socio-political context of public policy. Thirdly, the role of Sharia. And fourthly, the past experiences with international arbitration against state entities. I will try to go briefly through each of these four reasons. Firstly, the judicial understanding, the historical judicial understanding of the term public policy. From the time that the notion of public policy is introduced to a given legal system, say by virtue of the enactment of a civil code, up until that country becomes a member of the new convention or adopts the ancestral model law on international commercial arbitration, the notion of public policy has ample time, sometimes a good number of decades, to make a history of its own. So when that country ratifies the new convention or adopts the ancestral model law, the term public policy has already a deep-seated effect on the minds of the judges that are the ultimate applicants of these acts and the convention. And that deep-seated effect is effectively much more influential in the minds of the judges than any admirable, valuable, but still non-binding efforts on the part of international organizations that issue various non-binding guidelines. And bear in mind that we are not talking about the countries that have devised this whole international arbitration machinery and can accommodate themselves with the new developments more easily, but countries that have simply imported the international arbitration. So as a result of this, you can see that on various occasions, notions regarding, for instance, procedural public policy have found a successful application in post-war proceedings in the Middle East. If I want to identify two common themes in multiple jurisdictions, for instance, if the court recognizes that it does not have subject matter or territorial jurisdiction with respect to the dispute or the parties thereto, in an enforcement proceedings, they would dismiss the enforcement application on the basis of public policy because they would deem jurisdictional matters as matters of public policy. And secondly, you can see that if the arbitral tribunal fails to abide by the technicalities and formalities regarding domestic awards and judgments, again, the courts, various courts in the Middle East, have refused to recognize or enforce that award because of the violation of procedural public policy. And this has been a common theme in various Middle Eastern jurisdictions. That was the first reason. The second reason is the socio-political context of public policy, which is the proverbial unruly horse, which is a philosophical term and cannot be detached from a socio-political context. And part of this socio-political context is the governance model in Middle Eastern countries, which I should say in very general terms, and I should emphasize this qualifier, the role of the public sector in the economy of various Middle Eastern jurisdictions is much larger when you compare it to the role of the public sector in Europe, North America, and Southeast Asia. And this magnitude of the role of the public sector and economic undertakings associated with public figures has effectively, in practice, materialized in the form of a larger domain for public policy, sometimes in the form of economic public policy. And one upshot of this larger understanding of public policy has been, in effect, that in multiple jurisdictions, again in the last decade, many arbitral awards have been annulled or refused enforcement because domestically applicable conditions for referring arbitration, disputes involving state entities to arbitration have not been observed. So yeah, you can see many of these examples in the last decade. Thirdly, Sharia. As I mentioned at the beginning of my presentation, there are about 15 countries predominantly populated by Muslims in the Middle East. And that means that Sharia has a significant role in the legislation in these countries, including on matters of international arbitration, and as a result, also matters of handling matters regarding public policy. And you can see that in various arbitration acts, domestic arbitration acts, you can see Sharia has been mentioned alongside public policy. For example, if I'm not mistaken, Article 50, Paragraph 2, and Article 55, Paragraph 2b of the Saudi Arbitration Act, the new Arbitration Act of Saudi Arabia, Sharia has been cited, has been mentioned next to public policy. And one upshot of that application of Sharia in the context of post-award proceedings in various countries, not just Saudi Arabia, but many countries in the Middle East, has been that arbitral awards entailing compound interest or even simple interest have been partially or fully annulled or refused enforcement in the jurisdictions. And finally, this is something that you really have to put yourself in the shoes of the Middle Eastern jurists. My generation and the generation probably before me, we have been educated and brought up by reading arbitral awards rendered in the 1960s and 1980s against various state entities in the Middle East, states and state entities in the Middle East. And those awards have against state entities have been perceived to sometimes contain bitter languages and in favor of the foreign investor. Of course, the scene has changed now, but we are talking about the historical impact of that understanding and that perception. And that is something that almost all countries in the Middle East have some level of experience with. And that is also another factor that has contributed to a more reserved approach towards awards rendered against state entities that are associated with the recognition or enforcement forum, or the forum that is reviewing the validity of the arbitral award. So these are the four reasons that I think have had an impact on a more expansive reading of the ground of public policy in post-award proceedings in Middle Eastern countries. Let me conclude by saying that in the last 35 years, there have been remarkable developments in the application of the new convention in the Middle East. And when you see the commentaries, you can see that jurists are reporting with pride and excitement the pro-arbitration approach of their countries. But as I tried to show, there is still room for improvement. And thinking of the promotion of the harmonization in the application of the new convention, all the reasons I identified, they implicate respectively the judiciary, the legislative power, the judiciary, the executive, the legislative power, and the academia. And when you want to find a solution, it is very important to bring all these stakeholders together. So it is only then that you can find a proper solution for the interpretation of the term public policy. And let me finish by sharing an anecdote regarding, for example, how it is important to hear the judges as the ultimate applicants of the new convention and listen to what they have to say in this regard. In the margins of a seminar, I met a judge who happened to be entrusted with applying the new convention. And he told me that, and he was from a Middle Eastern jurisdiction. He told me that, look, the new convention is now part of my legal system, and I have to apply it. And I really tend to interpret the term public policy narrowly. But at the same time, there are domestic judicial discipline regulations in my country that would say if a judge fails to observe the mandatory laws and Sharia in his or her judgment, he has committed misconduct. So he would complain that my hands are tied, and these regulations do not make a distinction between situations when you're applying an international convention and in totally domestic settings. So when you hear them, you become familiar with their day-to-day entanglements, and it is only then that you can find proper solutions for actual problems. That's me. Thank you very much for your attention. Happy to hand the floor back to you, Stavros.
Thank you very much, Dr. Eftekhari. I want to connect what you said right now with what Professor Banteca said, because that judge that spoke to you, that says that there is no difference between applying Sharia law when applying an international convention or when interpreting domestic law, would probably not be, unfortunately, not be particularly moved by the articles on state responsibility or the Vienna Convention on the law of treaties. You're going to say, well, if I don't interpret Sharia law, I'm going to be accused of misconduct. Whether I should be accused of misconduct in accordance with international law is of no interest or little interest to them in any event. So I understand the point. I wanted to ask you one question based on what you said, and basically add another parameter. You mentioned the perceptions of the judges prior to the introduction of the ratification of the New York Convention in a particular state. I would like to add the perception of the lawyers as well. We recently actually had a case where the arbitrator asked us, "Do you want us to sign every single of the thousands of pages of the award?" And based on the New York Convention, anyone would have said, no, it's not necessary, but the current trend. However, do we really want to take a chance when the client is actually depending on it? My question is, do you see in the next 20 or 30 years, do you see any changes in that perception?
Yes, of course. I would say that the trend is moving towards pro-enforcement in the Middle East. And the experiences that we have had, so if you make a distinction between the offshore and onshore jurisdictions, you see that the offshore jurisdictions are doing it much more liberally, but the onshore jurisdictions have to be a little bit more conservative. But I think they will also come on board with the passage of time. And seminars like this, when we can gather all the stakeholders, these are really, really helpful. And so if you look back like 30, 35 years ago, there were many more limitations, and these limitations are being removed one after the other. And this is not a limitation which is sustainable. So this is the example we are talking about is a mere technicality. It is not something, as I think we will be hearing the fantastic cases from Switzerland, from Constantine. These are not something which are connected to the most basic morals of the countries in the Middle East. So these will be things that I think will be handled much more efficiently in the future.
Excellent. I have one last question before moving on, and you actually, beat me to it to an extent, because you mentioned onshore and offshore jurisdictions. For the benefit of everyone who's watching, we had a panel right before this one on basically on offshore courts and international court systems such as the DIFC, the QFC. Do you see, in your experience, do you see any dialogue or any exchange of views between onshore and offshore courts when it comes to these matters?
Well, of course, because in the offshore jurisdictions, if I understand that correctly, if my understanding is correct in that regard, the law applied is different, and the judges that apply the law are also different, with a different background and education. So in the end, it wouldn't be like two ships passing each other in the dark, but it will be something that will create a dialogue in the future. And I think when not only the offshore jurisdictions in the same country, but when you have examples from other countries in the region, it would be encouraging also for the onshore jurisdictions in the country we are implying. It would also encourage them to interpret the term public policy with regard to these technicalities and formalities much more restrictively. So in brief, yes, I think that will definitely what they bring, what their common law background brings to the discussion, to the dialogue, would be a positive takeaway.
Thank you very much, Dr. Eftekhari. One certainly can hope. We would like to move on from the Middle East and move on to other jurisdictions, some more liberal, to differing jurisdictions, actually. We would like to find someone who will be able to guide us with respect to both. Mr. Constantine Christy is a partner at the global law firm Peter and Kim. He's in Switzerland. He's a US qualified lawyer with many years of experience in arbitration, commercial and investor state, focusing on a number of sectors, but primarily in oil and gas and the automotive and heavy industry. He will speak about recent developments in Switzerland and to an extent Russia, and also discuss certain thorny issues, especially with sometimes regarding to sanctions. Constantine, the floor is yours.
Good afternoon. I speak to the camera, and yeah. So if everybody can hear me well, with many thanks to Stavros and for making me the honorary Greek. My name is Constantine, but I guess I could be Kostadinos as well. I could be Taki. In arbitration, we have many names and many different cultural perspectives. And I am one of those arbitration kids. Long, long ago, I grew up partially in Russia, partially in the United States, and I've been based now in Switzerland, which is has a fair and I think justified place on this panel of a World Arbitration Update, because according to I think Queen Mary survey, last one, Geneva was within top 5 arbitration seats, which means that Switzerland handles quite a number of cases from different parties, and the Swiss Supreme Court. Before I start my presentation, I have to remind everyone, perhaps those who are not familiar with Switzerland, that in Switzerland, the right of appeal or set-aside proceedings, there's only one level, and all the cases go directly to the Swiss Supreme Court, which handles all the tasks. So with this, let me perhaps slides. All right, so as has been foreshadowed by Reza, there's quite an interaction between New York Article V, as somebody called it, and New York Convention Article V, and Article 5, of course, and public policy exception. And what you see on the screen is basically the legal basis for the application of the same principles. This is Swiss Private International Law Act. And I have to say immediately that just as our friends in common law, and Switzerland is a civil law country fundamentally. It has a sort of a Germanic basis. It's not a Napoleonic code country as much as, although Napoleon did pass the Canton of Geneva. And actually, that's one of the reasons, a historical anecdote, why Geneva is part of Swiss Confederation. But that aside, it's really a Germanic based. It has a very progressive commercial code and civil code, and also a very pro-arbitration position in terms of review of set-aside awards. There is a possibility to opt out from Article 190, which you see on the screen, which governs the decisions of arbitral tribunals being reviewed, but that simply means that the Article 393 of the Swiss Commercial Code, Civil Code of Procedure, will be applying, and there will be a review of the decision for arbitrariness. The chances of success on your screen, I was trying to be a little bit say controversial, but it is in a way true. We say to our clients all the time that already for non-public policy, you have very low chances. Roughly less than 5%, but for public policy, if you're trying to invoke that, you basically have 0% according to the last overall statistics, and 0.9% for sports cases. Why I'm saying that? It's simple math. in roughly 220 cases that have been heard on public policy, there have been only 2 awards which have been set aside, and we'll come to seeing some of them. Now, the notion of public policy, and I had to review a little bit of this before giving a speech, but essentially it's nothing that Reza and other colleagues on the panel, basically nothing that they haven't heard before. It's basically refers to a widely recognized system of values, which is common to many legal systems. It's has to be logical, has to be fair, has to be justice being served. And the Federal Supreme Court, or Federal Supreme Tribunal, as we refer to it, which basically the Swiss Supreme Court, also applies the public policy to substantive and procedural components. This is perhaps an important point. The most important point for everyone to remember dealing with Switzerland is that you may have an arbitration decision that does violate the public policy, but if its reasoning does not sort of have an actual pragmatic impact on the outcome of that decision, the Swiss Supreme Court will not set it aside. Coming back to the Article 5 of the New York Convention, of course, there's the tension that has been mentioned by my colleagues about, well, you have the state, the legislature, which actually does want to promote, let's say, the arbitration, and we have in Switzerland a periodic review of our law applicable to arbitration, the review of arbitral awards, and then it's the judges that actually do apply. But here, I think New York Convention is quite clear that it refers to the public policy of the enforcing state. So Switzerland takes its own Swiss notions of justice, and then, of course, it looks at other overall positions of other, let's say, mature legal systems in trying to understand what the Swiss notions of justice would be. So they don't look just purely in Swiss law; they look at other provisions. It could be other nations. Some of the examples that come up here, and that I need to bring to your attention, is one interesting one is on pacta sunt servanda, which basically says that it would be a violation of public policy if a decision does affirm an existence of a contract, but then ignores the consequences of that contract, that contractual provision. Of course, the usual, which you see in many jurisdictions, it's the violation against bribery. Similarly, there has been a case where a decision was set aside, a decision of the arbitral tribunal was set aside because the public policy, it was against public policy to try to enforce basically make a de facto ban from a profession. In this case, I believe, sports profession, for failure to pay an association fine. There's on the other hand no automatic qualification of European Convention of Human Rights or the Swiss Constitution as automatically meaning that there's a violation of public policy. Further, you see on your screen some of the cases where it's been confirmed that this would not constitute a violation of public policy: excessive contractual penalties, contingency fees, the various rules on burden of proof. There has not been taken a position yet in terms of force majeure and reformation in peers. It's to be seen, but it was interesting to hear from Reza, for instance, the notion of Sharia. Of course, the compound interest provisions, they're quite often being invoked, I think, as violative of commercial provisions in this region. And Switzerland has not taken sort of a specific position on this, but I would imagine that compound interest is quite normal in a case. In one of my cases, in fact, an arbitral tribunal affirmed an interest rate of 25%, which is quite excessive by Swiss standards. And we were even thinking of trying to maybe make a claim for violation of public policy that this would be contrary to any sort of standard. But then one has to remember that in Swiss context, unlike some other jurisdictions, even if there is a affirmation and setting aside of the arbitral award for public policy or any other reason, then the decision, the arbitration basically, or the arbitral award goes back to the same arbitral tribunal. So the same arbitral members on the panel would have to then review the decision of the Supreme Court and will have to amend the award. So that means that there's a certain risk, of course, as well, that the arbitral tribunal members, who are human beings, they might be annoyed and they can always come up with a reasoning, maybe. So you sort of take a really long and hard look whether it's worth it going first all the way to the Supreme Court, have the decision set aside, or knowing full well that the same decision will basically be then reviewed by the same tribunal. And this is something that practitioners in Switzerland have been discussing about, and maybe making it, I believe in Singapore, for instance, this is not the case, and it's a completely different panel that then reviews the decision of this, whatever, appellate court that sets aside the arbitration. So there's also some procedural public policy, of course, context which needs to be invoked here. Swiss Supreme Court recognizes that, as I said, public policy applies also to procedure, and their excessive formalism, like in some countries, you see, I believe in particular in China, the award has to be, if the institution is based in mainland China, you have to sign physically the award in mainland China. Such excessive formalism doesn't apply, but it does apply to impartiality and independence of experts. This has been found as a particular ground if the arbitral tribunal ignores notions of bias. And res judicata, there has been a specific case in a sports context where one of the clubs was successful in actually annulling the decision of the arbitral tribunal for ignoring its earlier decision, and the Supreme Court confirmed that. Now, I want to switch to another civil law jurisdiction, which is quite interesting, has been quite in the news lately, and this is the Russian Federation and its recent decision-making process that basically applies public policy to an anti-suit injunction regulation or anti-arbitration suit regulation. Article 248 of the Russian Commercial Procedural Code allows parties to seek injunctions when they are involved in legal proceedings or arbitrations outside of Russia and try to basically seek an injunction against an arbitral tribunal to make sure that the litigation takes place in Russia. Now, there are severe penalties that could be sought by a Russian party against such violations of such decisions, and the Russian courts have been quite easy in granting such anti-suit injunctions. For instance, there's no longer, although this law was promulgated in 2020, and confirmed by a court decision on 9 December 2021, before the sort of latest manifestation and the most active war in Ukraine in February 2022. There has been now a new development in the sense that there's no longer a need to prove by a Russian entity involved that's seeking the injunction to say that it has been sanctioned itself. It's just enough to broadly sort of suggest that it's experiencing some sort of restrictive measures, and these can be as broad as to say that, look, Visa and MasterCard have now pulled out from the country, we no longer can make payments. And the Russian various state-owned and other parties have been quite successful in using this provision in order to seek the injunction. And of course, according to the law, while we are speaking in this panel, in this context, is recognition and enforcement of these awards issued despite arbitral awards issued despite anti-suit injunction will be denied on public policy grounds. So this is quite a concern. And just to give you one recent example, there was a decision recently a court imposed a $1.5 billion injunction or fine against Europol Gas in case it breached its injunction in the case started by Gazprom. So I'll leave it there, and then I thank you very much for your attention.
Very good. Thank you. Thank you very much, Constantine. The 0% was indeed quite startling. However, I just want to point out, first of all, that the bribery concept that you mentioned is basically existing in even the most liberal of jurisdictions. By way of example, there was a recent decision before the English courts that set aside an award that was essentially, procured by corruption. It was very recent, and it was somewhat criticized, but it did really show that there is a limit, and that limit is corruption. I wanted to ask you something. As a lawyer in Switzerland, you have a client, and you're in the process of drafting an arbitration clause. You're in the process of drafting an arbitration clause, and you are thinking of a seat. Does, in the mind of a lawyer, the public policy exception work more as a destabilizing factor, or in case you win, or as a safety net in case you lose? My point is that in certain cases, if you think that there are some issues of public policy, the question is, okay, maybe I'm going to go to this arbitration, maybe I lose the arbitration, but if I choose a stricter jurisdiction, maybe I can have that award set aside. Is that something that you or any other lawyer would take into account?
I think honestly, most lawyers would take a position that unless you have a specific jurisdiction which you're dealing with, such as Russia, to give one example, or another jurisdiction where you may be actually being favored by a quite wide-ranging or wide interpretation of the public policy, and you might want to have that award set aside, then you just advise your client to go for one of the major centers of arbitration, where you have a stable network, you have a stable jurisprudence where you can actually predict, so to speak, what will happen with that award.
Okay, thank you very much. Thank you very much. Last but not least, we have Stella Lepturgou. I'm afraid that a recital of Ms. Lepturgou's accomplishments and titles may be longer than her speech, so I will try to keep it to the essentials. She's a dual qualified lawyer in Paris and Athens. She's counsel in charge of the Middle East team at the Secretariat of the ICC International Court of Arbitration in Paris. She has supervised and administered several hundred ICC arbitrations in the region and beyond, and has performed the scrutiny of more than 100 arbitral awards. She's also the founder of Arbitral Women in Greece, aim to promote the arbitration among women in the country. She will speak about the procedural aspect of public policy from the point of view of an arbitral institution. More specifically, she will explain how the ICC in particular deals with issues of public policy, inter alia, to avert potential set-aside and or a refusal of enforcement. Ms. Lepturgou, the floor is yours.
Thank you, Stavros, and thank you very much, of course, to the organizers for the invitation. I'm also honored to be part of this wonderful panel. And for once, I may not contribute to diversity through my Greek nationality, but at least I do so through the fact of being a female, so that's already good. So as Stavros pointed out, I will be discussing this very interesting question from the institutional standpoint. So what is the role of the ICC when it identifies in the course of the arbitration a potential violation of public policy? And what are the limits of this role? So let me just first start by stressing that the ICC's role, first and foremost, is to ensure that any award rendered under its auspices is valid and enforceable at law. And this is essentially an obligation placed on the ICC under Article 42 of the ICC rules. And as very helpfully explained by my co-panelists, the breach of public policy is, in most jurisdictions, if not in all of them, a ground for setting aside an award. And under the New York Convention, it is a ground for refusing the recognition and enforcement of an award. So with that in mind, the ICC has established several rules and practices in order to protect the integrity of the process and of any award that is issued. Those rules and practices may concern different stages of the proceedings, from the constitution of the tribunal to the scrutiny of the award. And I will actually focus on these 2 points because those are the instances where the role of the ICC is more active, more essential. So starting with the constitution of the tribunal, this is very closely linked to considerations of equal treatment of the parties, due process. Those are principles that do constitute public policy in most jurisdictions. So if the parties are not treated equally at this stage of the constitution of the tribunal, the award may ultimately be set aside or refuse enforcement. So the ICC rules contain provisions that expressly grant the institution the power to take measures in order to make sure that the parties are treated equally. And the ICC has applied those in several occasions in order to avoid a potential public policy violation. So let me give you just 2 recent examples. The first one concerns a corporate dispute between the minority shareholder of a company acting as claimant, on the one hand, against the liquidator of the company as first respondent, and the controlling shareholder of the company as second respondent. Claimant has claims against both respondents, but also respondent 1, so the liquidator, has claims against respondent 2, the controlling shareholder. So respondents do not have aligned interests in the arbitration. The arbitration agreement provides for 3 arbitrators. Claimants nominated the arbitrator, but respondents who have divergent interests fail to agree and fail to join to nominate the arbitrator. In principle, the ICC court could confirm the arbitrator nominated by claimants and appoint a arbitrator on behalf of respondents who failed to nominate. That said, this approach has in the past, in the famous Datco case, led to the annulment of the award in France on the ground of breach of public policy due to the unequal treatment of the parties in the constitution of the tribunal. And why was that? Because respondents who did not have aligned interests were somehow forced to share the same arbitrator, an individual whom they did not choose, but who was appointed by the ICC court, while at the same time, a claimant could have an arbitrator of its own choice. So having this in mind, and in order to safeguard the award, in our example, the ICC court decided to exercise its power under Article 12.8 of the ICC rules. So instead of confirming the arbitrator nominated by claimant and appointing a arbitrator on behalf of the defaulting respondents, the ICC court appointed directly all 3 members of the tribunal. That would ensure equal treatment between the parties and would avoid a public policy violation in circumstances where respondents were unable to join the selected arbitrator precisely because of their diverging interests. Now, the second case that I want to share concerns an arbitration agreement that provides for 5 arbitrators, quite exceptional, and stipulates specifically that each party shall nominate 1 arbitrator, and the 4th arbitrator shall nominate the president. Now, the problem in our case is that we have 1 claimant on the one hand and 3 respondents on the other hand. So if the procedure agreed on in the arbitration agreement were to be followed, that would lead to an unequal representation of the 2 sides within the tribunal, with claimants having 1 arbitrator and respondents having 3 arbitrators. So in this instance, the ICC court finally decided to, again, appoint directly all 5 members of the tribunal, according to Article 12.9 of the ICC rules this time. And this, notwithstanding the specific procedure for the constitution of the tribunal that was expressly agreed on by the parties in the arbitration agreement. Now, what was the rationale behind the court's decision? The court considered that following the procedure set out in the arbitration clause would create a significant risk of unequal treatment between the parties and unfairness that would constitute potentially breach of public policy at the place of arbitration and would therefore jeopardize the validity of any award that would be issued. Now, ultimately, claimant was the winning party and sought to enforce the award in the BVI. Obviously, respondents argued that party autonomy should be the limit to the institution's powers, and that in this instance, the ICC court had exceeded those powers and had breached this basic principle of party autonomy by disregarding the parties' agreement as expressed in the arbitration clause. Interestingly, the BVI courts enforced the award and complemented even the ICC court's decision. So we can see that the ICC court enjoys wide discretion at the stage of the constitution of the tribunal, especially when considerations of public policy arise. And even the parties' agreement may at times not limit such discretion. Indeed, when faced with such a decision between safeguarding party autonomy on the one hand or equality of the parties on the other, the court would veer in favor of the equality of the parties. Why? Because this is considered a matter of public policy in most countries. So the aim is ultimately to protect the award and finally the parties and the integrity of the process. Turning now to scrutiny of awards. Maybe just a very brief reminder at this stage. Under the ICC rules, any award drafted by the tribunal should be reviewed by the ICC and approved by the ICC court before it can actually be issued and notified to the parties. So the ICC's role is very active at the stage of the scrutiny in order to ensure, to the extent possible, of course, that the award will not be set aside and will not be refused enforcement, among others, due to breach of public policy provisions. Now, what does the ICC court do when it identifies potential violations of public policy at this stage of the scrutiny? Essentially, it would draw the tribunal's attention to those deficiencies and may ultimately, depending, of course, on the circumstances, not approve the award until such time as the deficiencies are cured. This is really assessed on a case-by-case basis, so it would depend on the importance of the deficiencies, the place of arbitration, the place of potential enforcement, etc., etc. So a typical example that was mentioned by Stavros, where the ICC court would be particularly careful and hands-on at the scrutiny stage, is where there are allegations of corruption. So in most jurisdictions, if not in all of them, corruption is against public policy. The ICC court will review very closely the assessment made by the tribunal and will make sure that this is in line with the test that is applicable in the relevant jurisdiction. And my co-panelists mentioned several different jurisdictions, and it's very interesting to hear the different approaches. I think that France deserves a special mention in this regard. First of all, Paris is indeed one of the most popular seats, at least in ICC arbitration, and especially in cases related to the Middle East. And also the French courts have recently shifted their stance towards corruption. And this shift has indeed had an important impact on the way the ICC court approaches the scrutiny of awards in cases seated in France. So pursuant to Article 1520 of the French Code of Civil Procedure, the award shall be set aside if its recognition or enforcement would be contrary to international public policy. Traditionally, French courts, as most jurisdictions, had established a minimalist, let's say, review of awards in the context of annulment proceedings, even in the presence of corruption allegations. So the review of the merits was prohibited. The national court would not question the tribunal's findings. It would not accept new evidence. This approach seems to have shifted in the recent years in France. The French courts have now very extensive powers. They can conduct a de novo review of the case, both in fact and at law, and can even order the production of new documents that were not before the tribunal. And the Paris Court of Appeal recently held that it has the duty to seek all the elements, allowing it to establish whether the recognition or enforcement of the awards would be compatible with international public order. So indeed, in a series of recent decisions, essentially relating to corruption and money laundering, with a special mention to the Bellocon and Alstom cases, the Paris Court of Appeal set aside or refused the enforcement of certain awards. And in all of those cases, the tribunal had found that corruption or money laundering, respectively, had not been established. After reassessing the evidence, the Court of Appeal was then satisfied that there were actually red flags and that the recognition or enforcement of the awards would be contrary to international public order. Interestingly, the Court of Cassation upheld the decisions of the Court of Appeal very recently. It was in 2022, if I'm not mistaken, and it confirmed that the Court of Appeal was not limited to the evidence submitted to the arbitrators and was not bound by the arbitrators' findings, but it can make its own assessment as to whether there are serious and precise indices of corruption or money laundering. And I would also like to mention two other recent decisions. Those are issued in investment cases against Libya and Gabon, respectively, where the French courts again set aside the awards on the ground of violation of international public policy. Now, the particularity in those cases is that the states had not raised the issue of corruption at all before the tribunal, but only after having lost, they alleged corruption for the first time before the Paris Court of Appeal. Interestingly, again, this did not prevent the French court from assessing all the new elements produced by the respective states. And in both cases, the court concluded that there had, in fact, been corruption and that, therefore, recognizing the awards would be against international public order. So we can see that the powers of the French judge are very extensive now. They are not limited by any assessment made by the tribunal, any evidence presented to the tribunal, or even any arguments made before the tribunal. Now, the only limits to their review are the ones imposed by the principles of due process, equality of arms, just granting all parties the possibility to comment and file submissions. So this so-called maximalist review performed by the French courts in the presence of corruption allegations, and also, of course, the number of recent awards that have been annulled or refused enforcement in France on that basis, has forced the ICC court to be even more careful at the scrutiny stage. So if there are any elements on file that raise suspicions of corruption, the ICC court would typically insist that the tribunal verify whether these may warrant further and more thorough assessment. So to wrap up, the ICC maintains indeed an important role in safeguarding an award that is valid and enforceable at law. This is what guides any decision that the ICC takes from the very beginning until the very end of the arbitration. That being said, the ICC is simply the guardian of the proceedings, but the ultimate decision maker is the tribunal. So the ICC's role ends where and when the tribunal is satisfied that its decision is ultimately in the best interest of the case and in accordance with public policy. And that's all for me. Thank you very much for the attention.
Thank you very much, Stella. You raised two very interesting points. One was the selection of arbitrators in the concept and the concept of party autonomy and how that clashes with the equality of arms. I would be, you don't have to say, but I would be interested to find out what the seat of the arbitration was and whether the award was set aside there, because certain jurisdictions say that party autonomy is the ultimate public policy ground, and it's even higher than any equality and all that. If, for example, the parties selected this approach, this method for the selection of arbitrators, and that should be respected. And the intervention, and the approval of this approach or the rejection of this approach is something that makes law and comparative law so difficult. I would also like to point out, I was very interested to hear about the new Paris cases. They were very interesting. It would be good to know what the standard of proof was in these cases, because as you very well know, especially in cases of investor-state arbitration where corruption is practically impossible to prove, sometimes the tribunals, follow a slightly lower standard of proof. However, I don't want to monopolize the conversation. I want to open the floor to questions from the attendees, either online or in person, or in person. Yes, I said that right. Are there any questions from the crowd? No? Anyone online? Oh, excuse me. Yes, please.
Thank you so much for the conference. I think this kind of conferences relate them sometimes in Doha, speaking about substantive issues like public policy, and it's a very interesting question, especially in the region. I'd like just to touch on a couple of points that have been raised. First, it's enjoyable to have a really great panel in Doha. And I think that I've worked with a lot of bright Greeks in arbitration. And I think you represent, as Greeks, you represent really what international arbitration represents in terms of culture and history and mediation, if I can say in some way. I'd like to touch precisely on the point that Stella had raised concerning the new case law in France about how corruption is appreciated in general. And being a French lawyer as well, I truly appreciate what the case law has done by going into a maximalist, if it can be said, kind of review. I know that generally arbitration practitioners are very skeptical when it comes to real review of awards and all of that. But I truly think that if we're speaking about public policy and we're speaking about corruption and fraud, if there is an area in which the courts would really focus the review, it would be in these circumstances, and being very arbitration friendly in the way that you wouldn't be reviewing anything doesn't actually serve the system, it deserves it. So I think what happens in these cases is very well, and it pushes the ICC and other institutions into also focusing on this kind of situation and trying to manage at best if there are any cases of potential corruption. And there are a lot when we have experienced a lot. So although this is in general seen in a skeptical way, I think that's a good development. And still, the French courts would have to learn from the Swiss Supreme Court on how to draft the decisions, I would say, because they draft them in very high level way without really explaining how they reasoned. But in cases of corruption, they don't do so. So they tend to be more of Swiss in this sense, but we still need to learn the Swiss way of prefacing scholar opinions and other decisions as well. Then just on the point that Stavros has raised about the lawyer's role when it comes to public law policy and application of public policy, I was personally moved recently working on a case here in Doha with colleagues in which we had an arbitral tribunal, mostly of British, either chancellors or president of the tribunal, a former judge of the High Court in the UK. And when it came to the time in which the tribunal would render its decision and it asked the parties, is there any formalities that the parties would like us to take into account in order to really safeguard the award when it would be rendered, and it was issued in Doha. I was really moved by seeing that the parties actually requested that the tribunal put a sentence that this is rendered in the name of the Emir. And I'm speaking about the case which was maybe 1 month ago. And this was suggested principally by the respondent. And then there was a decision that, and my colleagues who were representing the claimant side, I wasn't personally working on this case. And I was like telling them, no, like this cannot make sense. And you shouldn't just be pushing and being like, as lawyers, we generally tend to be conservative, but this doesn't serve the system in any way. So you need really to say, no, there are different case law, and this has been resolved now. And it doesn't actually make any sense to say that the award has been rendered in the name of the emir. Like if I'm advising the emir, I would even say, who the hell is this tribunal that is telling right? So it doesn't make sense, and it can actually be a reason for setting aside to be rendered in the name of the emir, although it is just private arbitration. And I was also surprised to see that even the president of the tribunal, who is a former high court judge, was actually believing that, okay, let's be on the safe side and render it in the name of the emir. So I think that we have all a lot to do in this kind of situation. I'm not speaking about something that was 7 years ago. This was 1 month ago with a notable institution managing the arbitration and very experienced practitioners from all sides. So thank you so much.
Very good comments, and I will briefly summarize them. Our colleague here is basically focused on the last speech and said that the analysis of corruption basically is by the French courts is a step in the right direction in the analysis of public policy. And that is something that I alluded to when discussing Professor Bantekas's speech, that it's one thing to have a laissez-faire approach and just defer to what the tribunal did. And it's another and quite another thing to actually engage and see whether this is a public policy issue and whether it has been proven adequately. The comments about the French courts were very, very poignant, in my opinion. I would like to see how a French judge would respond to them. Probably not very, not in a very accepting manner, but I do agree to a great extent. And I do think that the drafting of the decisions is a matter in which, cross-cultural exchanges would be very helpful. And on the matter of how lawyers interpret issues of public policy, once again, I do agree with you that to the extent that something has been settled with, for example, drafting the award in the name of the emir, especially in Dubai, this has been, settled definitively. I also think that lawyers should accept that and say and tell their clients, you know what, this is what's happening. However, as you very well pointed out, many lawyers tend to be a little bit more conservative. They tend to think of the client's interest in a more, risk-averse manner. And that is exactly what my question to Professor Eftekhari was about. When the lawyers themselves are actually a little bit on the conservative side, will that serve the development of international arbitration in the long end? Professor Eftekhari, if you can give a very brief response, and then I think that we're good to go, and we will be able to close the meeting on the matter of on this development based on the comment made by our colleague.
Yes, of course. This was exactly one of the awards that was in my mind. It was issued in 2012, and it's from that time that this matter of formality that has instilled itself in the judicial understanding of judges has materialized itself as a matter of public policy. And you're definitely right that, and I think other commentators that have also provided their comments on the issue agree with you. You're definitely right that the lawyers have to be conservative because all the award is for the enforcement. And so they cannot take any chances at that point. But the point that I tried to convey towards the end of my presentation was exactly for this reason, that we have to have a holistic view. So all the stakeholders can come forward and they can hear each other. And it is only through convening all these stakeholders that you can come to a reasonable and workable solution for the interpretation of the term public policy. Sometimes it is in the form of a revision of the Arbitration Act, but sometimes you need a higher decision from a higher court in the country to settle the matter. So it's not only in the hands of the lawyers that have to follow what's going on and have to be more conservative, but more in the hands of the executive power, also the legislative and also the judiciary, together with academia.
We agree 100%. It takes a multi-stakeholder approach, but at the end of the day, the buck stops with the legislator. That's my personal view, but I understand your opinion that there has to be a dialogue in order to reach the result requested. Professor Rivas, we give the floor to you unless there is anything else.
Thank you very much, Stavros. I wanted to, and before concluding, I wanted to ask, one last question, if I may, if patience allows, from all the speakers, and especially possibly for Professor Bantecas and also for Stella and Reza and everyone in general. There is an investment contract case, which you may all know, which is world duty free versus Kenya, and in that decision there is a reference. The facts include corruption, and part of the rationale of the tribunal refers to international public policy as well as to the violation of the general principle of law of good faith, and sort of it does combine elements of, on the one hand, public international law by reference to the general principle of law of good faith, and on the other hand, it does from my perspective combine a perspective also of international contract law by referring to international public policy. My question is whether on the side of public policy, in addition to corruption, other examples could also be included, such as fraud, or as funds obtained through money laundering or traffic of arms, etc. So I wanted to get a better sense whether the notions or examples that may be applicable from the perspective of violation of a general principle of law, such as of good faith, and might also be transferable to the notion, which is more of a contract notion, of public policy. I wonder what you think, and if I might be misguided or on the right track. Thank you.
That case raised a significant issue of law and anthropology, if I remember correctly, because it was whether or not that particular practice was something which was consistent with Kenyan, let's say, customary law, or whether or not it was actual bribery. So that was an interesting part of that. But I would say that anything that constitutes general principle of law would be an issue of public policy. But of course, with good faith, it's only in part of the world. So in the English law, that's, unless you specify it in the contract, then it's not a principle of the contract. It's outside the contract. But again, even if everything that constitutes a general principle of law is out there and available, it would have to be applied proportionally. I think as Stella mentioned in the and another speaker as well, that you can have something which is a violation of the mandatory laws and violation of public policy, but if it doesn't make if there's no consequence, there's nothing significant about its application, then applying it would be a violation of public policy itself.
Thank you very much. Sorry.
If I may add, in the context of investment treaty arbitrations, of course, the case that you mentioned is an investment contract case, an investment treaty case. But in the context of investment treaty arbitrations, which are based upon investment treaties, you always have a legality requirement. Almost always you have an express or implied legality requirement, meaning that an investor who wants to be eligible to be able to pursue its claim on the merits has to show that it has made its investment in accordance with the laws of the host state. And it is through that prism that many investment treaty tribunals have approached the matter, including where matters of corruption are also at stake. And you can see cases like Phoenix in 2009, which was dismissed on the basis of the lack of good faith, or 2013 in Metaltech versus Uzbekistan, chaired by Gabriel Kaufman-Kohler, where there was the corruption was proven, and it was the tribunal really had an initiative there. They took the matters in their hands, they followed it up, and there they relied not only on the notions of illegality in general, but you can put it in the framework of corruption or fraud, but also, to be on the safe side, the tribunal also relied on international public policy. So to make sure that the award that is rendered is not something that the tribunal has, because when you dismiss the case on the basis of illegality and you implicate the domestic law of the host state, you don't want to deny jurisdiction where jurisdiction exists. So I think the tribunal was conservative in that case. They also refer to international public policy. So it depends, to be short, it really depends on the legal system that is applied to the specific question at hand. I think if it is domestic law, then you have many of these notions that can be used, like bribery, fraud, lack of good faith. It really depends on the domestic law applicable.
I would like to hear Constantine's view on the matter.
Yeah, thank you. Just wanted to comment very quickly. It cannot be within the context of investment arbitration or commercial arbitration. It should not be too easy for the host states to sort of take investments procured by corruption. Let's be honest about it. Let's say a contract is procured by corruption. The whole project is done, and then the new government comes and says, "Oh, I'm sorry, we will not pay for this contract. We will not pay for this project simply because it was procured through a bribe." That becomes too easy, and this is why in your convention, as I just mentioned, it actually looks at the place of enforcement in the public policy in that country. So it has to be, I think, rightly as suggested by all the speakers today, there has to be balance struck, and there has to be dialogue among all the stakeholders for the application of these principles, but in perhaps not a knee-jerk reaction, or some of the cases which were quite interesting, as Stella mentioned, in France. I'm all for an active role of judiciary in review of some of these cases, but if they do, then they have to really get into the facts, and I actually do appreciate that a judge would look at all the facts of the case, perhaps even discover new facts. That is quite a good development. So I thank you, Stavros.
And maybe Stavros, just to add
Yes,
something, I entirely echo Reza's approach to Professor Rivas' question. I think indeed it depends on the specific legal system. And just to also answer precisely on the basis of French law, actually the standard that is applied is whether the enforcement or recognition of the award would be contrary to international public policy. And this applies in the same way, and from everything that I read, it applies in the same manner in cases of corruption, in cases of money laundering, in cases of fraud. The question is whether enforcing or recognizing the award would hinder the fight against illegality in obtaining a contract. So I think that those principles apply in the same manner in all those instances, at least in the French legal system.
That is excellent. Okay, understood, and I do tend to agree with Constantine in this particular case, that when discussing matters of public policy, again, it is not a matter of trend, it is not a matter of a knee-jerk reaction. It should follow a basic understanding of what role do we want public policy to have, what is the content of public policy, and is that public policy breached in this case or not. Otherwise, there is no stability in arbitration, and there is no benefit in having an arbitral process that, that can provide no certainty as to the result with respect at least to the issue of public policy. With that said, I think we are done here, Professor Rivas. Unless you have any other questions, we would like to thank the World Arbitration Update for its excellent, organization. There are many more events to follow, if I'm right.
Indeed. We have. Yes, today, thank you, Stavros, and thank you, Reza, as well as Stella and Constantine, for this pretty amazing panel and for going through various jurisdictions as well as the public policy exception and the reasons to annul or stay aside an award. Yes, indeed, there are many other panels. The next panel that we will be having is just give me a second. I will tell you right away. Looking at our calendar. Next panel that we will be having is the panel in effective cross-examination, expert witnesses. This will be in Warsaw, and then we will have the we'll have in Washington DC. We're having at 1 p.m. impact on investment arbitration of the U.S. and other countries' elections in 2024. So that's an exciting panel, given that we're having at least a high number of elections in the world, including in the U.S., but also in Mexico, Venezuela, and other countries in Europe, etc., in South Asia. So looking forward to having you all in those panels. There's also a workshop later on how to write a brief in international arbitration. So really, it's amazing that you were able to put it together in Doha, and hopefully you'll enjoy the rest of your day wherever you are, either in the Iran U.S. Claims Tribunal in The Hague or in Doha. So take good care, and thank you.
Well, I think from me, worldarbitrationupdate.com. Google it for future events. Thank you very much, everyone.
Bye-bye.
Thank you very much.